let's get this thing started. So to everyone who is joining us on this webinar this morning, thank you for joining the Blue Book Network, now powered by Dodge Construction Network, for our partnered series with the Cromeens law firm for today's presentation of employment law do's and don'ts. This is part 3 of 4, so thank you all for joining. There is going to be a link that will be sent out after this presentation to join for part 4 of the series. And also, if you had missed out on part 1 or 2 and wanted to catch up, there is a YouTube channel that the Cromeens has that you guys can visit to get all of the previous episodes of this web series to get caught up on any of the employment law. And special bonus for any of you Blue Book members who are going to be attending the in-person meet and greet, the GC meet and greet that's going to be taking place tomorrow from 3 to 5 at Ellen Brent's. Lee and Jackie of the Cromeens law firm will actually be there as well. So if you all wanted to ask any additional questions about today's presentation or anything about the law firm, they'll be there and they'll be more than happy to answer any questions. But since we do have a lot of ground to cover this morning, I'm going to turn it over to Lee so that she can get into introducing our host, Myra Maldonado. Lee, I'll turn it over to you.
Thanks, Maggie. I appreciate it. Well, hope everyone's having a great morning so far. I'm Lee Leppert, the Senior Creative Manager here at the Cromeens Law Firm. And if you're joining us for the first time in the series, or if you've been in attendance the last 2, we're so happy you're here with us today and really look forward to presenting another informative webinar to help you build a better business. And today we have Miss Myra Maldonado, who is an associate attorney here at the Cromeens Law Firm. Myra was actually born and raised in Ecuador and moved to the US when she was 8 years old. So Spanish is her first language and she's fully bilingual. And she's passionate about helping her clients as if they were her own family. And she's has a mission to protect her clients' best interests like they were her own. And today she's here to break down employment law, which is one of the most challenging areas of business ownership, as you may know. And it's also an often overlooked because running a business is no simple endeavor. So today you'll learn how to protect yourself, your workforce, and your business before something goes wrong. Really understanding the full ramifications of neglecting employment law and misclassifying your workers is a necessary skill to fully comprehend in order to protect your business. So you'll learn everything you need to know about classifying employees, the common misconceptions, how to do it correctly, what the potential dangers and repercussions are if you're doing it incorrectly. And we'll also discuss some non-compete clauses, what they are, how they work, and other ways you can protect your business from competition. And we did send that fill in the blank handout, so please follow along with that. You can fill in the blanks as Myra goes along. And without further ado, I'm going to go ahead and let Myra go ahead and take it away.
Thank you, Lee. Well, good morning, everyone. Thank you guys for being here this morning. Like Lee mentioned, there's a lot of good information in this presentation, and we just want to make sure we can get through it all. So if you guys have any questions, if we have time at the end, we can go ahead and address that. But yeah, this information has a lot of, this presentation has a lot of good information, and hopefully you guys can learn a little bit more about how to better protect your business and the best way to kind of, you know, go about paying your employees. So let's get started. So the first thing is that one of the biggest things for any company is trying to figure out, is my worker an employee, or are they more of an independent contractor? And this is important to try to figure out because you want to know what is the best way and the proper way to pay them. Am I responsible for paying them overtime? Because if you don't, then that can later have consequences in the future if it comes to light that you weren't doing things properly. So knowing how you classify your workers and how is the proper way to compensate them is essentially going to be very important when it comes to legally protecting your business. How do the federal wage and hour laws apply to you and your company? The Fair Labor Standards Act, also known as FLSA, is the law that establishes the things about minimum wage, overtime pay, record keeping, all of that affecting both full-time and part-time employees. And it's very much the important part of the law that kind of tells you, okay, what is the proper way to pay my employees? And nearly every single company is going to be subject to this law through what's called the enterprise coverage or the individual coverage. So we'll talk a little bit about in a little bit of a detail what each one means. And then you can kind of figure out, does my company fall under the either category, meaning is my company subject to the FLSA law? The first one is enterprise coverage. In here, your company falls in this category if you have at least 2 employees and an annual dollar volume of sales of at least $500,000 million. So if this description, if your company fits under this description, then you are automatically subject to the FLSA laws, and you're gonna have they automatically apply to you. So it's very important to try to figure out if you fall under this category. If you're not under that category, let's see if you fit into the individual coverage category. In here, it basically says that if the individual or the worker that's trying to hold you liable for the wage or overtime violations is somehow involved in the interstate commerce, then you're going to fall under the individual coverage category, and you are going to be subject to the FLSA wage and overtime rules. So one example in here, and let me see if I have those here. No. Well, let's talk a little bit about one example, right? It's very likely overall that you are going to be falling under this category one way or another. Normally, any good attorney could try to make an argument as to why one of your employees would fall under in interstate commerce, kind of related to interstate commerce, which means you would be falling under this category. So for example, let's say you have a painting company and you buy paint that comes from a different state, right? Well, now there is a crossing of state borders, meaning that you are now involved in that interstate commerce and you're now subject to the FLSA laws. So it's very important to kind of keep in mind if that's something that applies to you. Like I said, for the most part, a lot of companies, it's very likely that they're going to be falling under this category. So, you know, keep that in mind and make sure you understand that either one of these categories is going to make you subject to the wage and overtime rules. So what is the standard wage and overtime rule? Well, the rule basically states that the employer must pay the employee 1.5 times the regular rate for every hour that they work over the 40-hour work week, unless the employee falls under a category of being exempt. Most people know this rule, but not everyone is really fully aware of the importance of the definitions of what is an employee and when are they exempt, right? So we're gonna dig a little deeper into both of these words and talk a little bit about their definition, and that way you guys can kind of have a better idea of whether this person falls under either category. So it's important to know that only employees are subject to the FLSA wage and overtime laws. So one big misconception that a lot of people say, it's basically, well, my employee or my worker decided to label themselves an independent contractor, so that's what they must be. And that's not the way it works. It doesn't matter what you label the worker. It doesn't matter what the worker labels himself or herself as. At the end of the day, whether the worker is an employee, it all comes down to the discretion of the courts. And the courts use what's known as a 5-factor test to try to figure out, okay, are we actually looking at someone who is an employee, or do they fall more under the independent contractor? And like I said, it's up to the court's discretion. So it's not really a matter of what they want to be, the worker wants to be, no matter how much they beg you, they want to be an independent contractor, thinking that you're not going to have to pay them the way that you would have to properly pay the employee. It's more of like, where do they fall within the 5-factor test, and how is the court going to make the determination at the end? So let's talk a little bit about the 5-factor test that the courts use to determine if the worker is an employee or an independent contractor. You can see in front of you are the 5 different factors that the court is going to be looking at to determine the proper, I guess, label of what the worker is. Number 1, degree of control exercised by the employer. In here, the court is basically asking questions such as, who determines the hours of the shifts work by the worker? Who is responsible for the quality control? Does the worker work for any other companies? Who sets the pay rate? And if the answer to these questions is consistently the employer, then it's going to lean more that the worker is actually an employee, right? Because it's the employer who has more control over all these different things and situations. So the court is most likely going to lean towards the worker being an employee. Number 2, permanency of the relationship. In here, the court's going to look at how long the worker has worked for the same company. And if obviously, you know, the longer that the worker is with the same company, the more likely that they are to be an employee instead of an independent contractor. Factor number 3, skill and initiative required. The courts would be looking at things like the job duties and the tasks performed by the worker. So does the worker perform tasks requiring or drawing on extensive training? Does the worker advertise independently in the newspaper or the yellow pages? That they have their own business card, all that kind of stuff? And does the worker have their own independent website, right? So if we're looking at this kind of questions and the answers tend to be yes, then that hints more of like, okay, this person, this individual is more of an independent contractor, because it looks more like they have their business independent from your company. However, you know, if you provide the worker with all the training needed to perform the job, and they are not out here doing their own business cards for their own business or with their own website, then this factor is going to lean in more towards that worker being an employee, because it's more, there's more of a connection with your company. Factor number 4, it talks about the relative investment of the worker compared to the employer. So for this factor, the court determines who pays the overhead expenses, right? So is the worker reimbursed for any purchases or materials, supplies, etc.? Does this worker own his own equipment, or do you provide that for him? So obviously, you know, if you invest in your worker more than your worker invests in either your business or his own business, then this factor is going to lean more towards that individual being an employee over an independent contractor. And the last factor is potential for profit and loss. So the courts are looking here for what kind of consequences that the worker would suffer if the company started to lose money or grow exponentially. Meaning, did the worker make any investments that would lead to somehow get them getting an extra profit or some kind of loss? So if the answer to most of these questions are no, then this factor right here is going to lean more towards the worker being an employee, because they weren't really acquiring that benefit. So it's really important, like I said earlier, keep in mind that it really doesn't matter at all how this worker decides to label themselves. the courts don't take any of that into consideration. And it also doesn't matter if you pay them with a 1099. As you can see, that is not a factor that the court is looking at all. So go through these factors, kind of figure out, okay, where could this worker, what category they can be falling under, and focus on those 5 factors, because like I said, this is what the courts are looking at when they make the final determination. And only these 5 factors matters and how the court decides to apply them. So some important notes. It's important to keep in mind that Texas doesn't have any additional extra or separate wage and overtime law. They mostly follow the federal law. And in all of the factors, the 5 factors that we discussed, the most important one, the one that is, weighted most importantly by the courts, is the control factor. So like I said, that's the one that the courts look at all 5 of them, and they like to say they are all weighted equally. But at the end of the day, they tend to focus a lot more on the control factor, and they deeply analyze that factor to figure out how they're going to determine what the worker is. So like I said, Texas doesn't have any additional laws when it comes to wage and overtime. However, it's very different depending on what state you're working on. Some states do have a different law that differs from the federal laws. So, states like California or New York or other states, they have their own wage and overtime laws. So if you're working in other states, it's very important that you familiarize yourself with these laws and make sure that you're looking at everything so that you can, 1, classify your workers correctly, and go from there into, okay, how do I properly pay them? Because it's very important that you make sure you take care of those things before they complicate, and it leads to greater consequences, which we'll talk a little bit about later in this presentation. So now that we've kind of figured out whether your worker is an employee or an independent contractor, if they are an employee, well, let's see if they are exempt. Because another big misconception out there is that, okay, well, my employee is a salary employee, which means that they're automatically exempt from the wage and overtime requirements. But this is not true. So we're going to talk a little bit more about what employees fall under that exempt category, and just so you guys have a little bit of a better idea. So to be considered exempt, an employee must be both paid a salary and they must fit into one of the exemption categories. So the most popular categories out there are executive exemption, administrative exemption, professional exemption, computer employee exemption, highly compensated employee exemption, and creative professional exemption. If the employee is paid salary and fits into either of those categories or exemptions, then they would not be owed overtime. So for example, if we're talking a little bit about professional exemption, those are people that got that higher level education, right? So they have licenses. Like an attorney, they would be a professional. They would fall under the professional exemption. A doctor, someone, like I said, with that went through all those loops to getting that higher level education, they would fall under that exemption. Someone in the administrative exemption, that's somebody, for example, that has some discretion on the job. They have discretion on who is hired, who is fired, and they can give recommendations about who you should hire or who you should fire, and you actually listen to them. So they also tend to be the people in your company that make some managerial level decisions on the day-to-day basis. Those kind of people would fall more under the administrative exemption. And if they're paid salaried, then they are not going to be owed overtime. So we can have, I have a little example for you guys about the administrative exemption. I'm sorry. Like I said, this is somebody that, you know, would have a hired to say, you know, managerial level decision making in the company. So for example, if you have a receptionist, you pay her a salary, and you know that salary basically covers her 40-hour work week. As long as she is working her 40 hours that week and doesn't go over her 40 hours, then you don't really have to worry about the overtime, paying her that overtime. But if she is working over those 40 hours, well, now you're going to have to look at what are her job duties, right? What is she being responsible for? And do her job duties now have her fall under the administrative exemption? Because if they do, then okay, even if she works that overtime and you're paying her that salary, then you're still not gonna have, you're not gonna owe her that overtime pay. But if she doesn't fall under that exemption because her duties are not really what an administrative exemption would describe as, then you are not, you know, like, you're going to have to look into, okay, well, do I have to pay her overtime now? So in this case, maybe the best solution would be make sure she keeps at her 40 hours per week, and not really go over that. So that's just one of the examples for the administrative exemption. And hopefully that helped a little bit more understand that. A lot of this is like a case-by-case scenario. So if you come to us and you have this specific question about a specific worker, well, then it's going to be a thing of, okay, now we're going to have to ask you a lot more questions and try to figure out, you know, what are their duties? Where do they fall? Would they be categorized as an employee? Do they fall under an exemption? And kind of go from there and figure out, you know, what you are responsible for and what you're not going to be held liable for. So let's talk a little bit about the consequences of misclassifying your employees. It's very easy to kind of forget how important employment laws are when it comes to managing your business. Like I said, if you fail to follow the overtime wage and hour laws, then there's going to be many consequences, and it's going to harm your company because you're going to be held responsible for paying them a lot of money, plus added to all that attorney fees to defend you in any case. So here you have some examples of the consequences, things that might happen if you misclassify your employees and you don't pay them correctly. Some of these repercussions include payroll and federal tax violations and/or IRS audits, wage and overtime lawsuits, exponential penalties in a wage overtime lawsuit, collective action lawsuits, and even a Department of Labor investigation. We all know the government doesn't like to be shorted, so they are gonna go after you. They're gonna do their own investigations, and if you are found to be liable, it's gonna be a lot of not just headaches, but also a lot of money that you're gonna be having to put out to try to, you know, defend the lawsuits or try to, you know, defend against any kind of investigation from the Department of Labor. So like I said, if a worker has been misclassified, you're not paying them correctly, well, now the IRS is going to perform an audit on your company. It's going to create, more expenses from your part, and there's going to be an order to pay the taxes that you didn't pay the first time. You can also fall into a wage and overtime lawsuit, and in there, like I said, you're going to have attorney fees to cover whenever you're defending yourself. And if you are found to owe any employees unpaid wages and overtime, then you're also going to be responsible for paying those employees for the 2 years preceding the filing of the lawsuit. So once it's determined that there is an amount of unpaid wages and unpaid overtime that you are owed to an employee, well, now the law is going to require that number to be doubled, because the way that it is set out is we're not just gonna make you pay what you didn't pay them initially. Well, now we're gonna double that as a way to punish you for not following the law and not doing things correctly the first time. So it's gonna get even more expensive for you. So instead of taking care of things from the very beginning, doing things right from here, it could avoid you spending so much more money in the future, because like I said, add to the double damages that now you're going to have to cover, add all the attorney fees, and it's going to be just a very, very costly, and you want to avoid that from the very beginning. If you are caught violating the wage and overtime laws a second time around, well, that's just going to increase your damages, the damages that you owe to the employee, up to 33%, right? So now we're looking, instead of 2 years back, now they're going to be looking 3 years back, and they're going to dig up all that information. They're going to, figure out each employee that you owe money to, and all of those people can now come together and sue you in one big lawsuit, that's also known as collective action. So like I said, they're gonna make sure that everybody that hasn't been paid is gonna be notified. They're gonna go through your history from way back, 2 or 3 years, depending, and then all of these people can choose to sue you, meaning now you're going to be spending a lot of money in your attorney fees, because to have an attorney like myself go through all of it and try to figure out, review evidence, review documents, try to create all the arguments for the individual plaintiffs or employees in this case, it's going to add up to a lot more money at the end, plus all the damages that now you're going to be responsible for paying them. Another problem that you could face, another consequence of misclassifying your employees or your workers, is that the Department of Labor can open an investigation against you and your company. When they do this, they are going to force you to turn over all your records, your bookkeeping, all of that, and they are going to figure out, okay, this person's an employee, they weren't paid all of this amount. They're going to make their own calculations, and now they're going to issue a ruling to force you to pay each employee the amount that you still owe them. So we have here an example of something that we've kind of see in our office, or some clients that we've had. We had a client where one of their employees decided to call the Department of Labor and just casually ask a question about, hey, how should I be paid? How should they be paying me in this case? Well, then the Department of Labor decided to open an investigation into the client's business, and they found that approximately 20 employees were being paid incorrectly. So the Department of Labor then, did their calculations. They went back, they looked at everything, and they calculated how much each employee is owed and made my client pay all that money to all the employees. So they reached out to every single employee. They informed them that they owe them money, that my client owed them money. But the craziest thing, and it's also something very frustrating that we encounter in these cases, is that even if those employees that are owed that money never respond to the Department of Labor, they never show up, or they don't even want to receive or pick up the money that they're owed, well, you're never getting that money back. The Department of Labor keeps that money, and so you're still having to make out those payments, except that instead of going directly to the employee, well, they don't want it, so the Department of Labor keeps it. And I believe after 2 or 3 years, if they still can't locate the employee, or the employee doesn't want it, it goes directly into the Treasury, the U.S. Treasury Department. So it sounds, crazy or unfair, but that's just the way that the law is set out to be. In another case, we encounter something that, we talked about a little bit earlier, which is the misconception of allowing your workers to label themselves as employee or independent contractor as they choose. So in this case, one of our clients, they let the employees choose if they wanted to be classified as independent contractors or employee, and most of them said, I want to be an independent contractor. So they labeled themselves as that, and that's what my client took them as. But at one point, one of these employees, for the sake of this example, he'll be John, he ended up being injured on the job. And when someone's injured on their job, they want to find out, well, what are my rights here now? And they contacted an employment attorney, and this attorney figured out that John was actually owed overtime and filed a lawsuit against my client. So normally, when these people contact an employment attorney, any good employment attorney is gonna let them know, ask a few questions here and there, figure out, are you really an employee or are you really an independent contractor? And if they smell something fishy, well, we have a lawsuit now because they owe you all this money that they didn't pay you and you're rightfully entitled to. So the notice was sent out to almost like 50 of our clients' employees, and each one was given the opportunity to join the lawsuit. Like I said, once one person finds out they're not being paid correctly, well, now all of the other employees, if they find out they're not being paid correctly, they can join the lawsuit against you. And it creates this massive lawsuit that in my client's case, put him at risk of a 6-figure damage calculation. So, normally it's just a matter of a few questions and one person kind of figuring out their rights and then spreading the word. And well, now you have all these people coming after you for the money that you owe them. And they can all just team up and begin up against you, basically. So now that we've talked a little bit about the proper way to classify your workers, let's talk a little bit about how you can go about protecting yourself and protecting your business with things like, non-competes and non-solicitation agreements. A restrictive covenant, it's basically this fancy name that the law has for an agreement between a business and a worker, whether they are an independent contractor or an employee. And this kind of agreement restricts the worker from competing or soliciting the business's workers or their customers. And like I said earlier, these are known as non-compete agreements, non-solicitation agreements. So they restrict your worker, your employee, from essentially competing against you or taking your clients or taking your employees when they leave your business. Non-compete clauses. So in here, you know, Texas is the kind of state that prefers and encourages competition. They want to make sure that, you know, let the best man win kind of state. So while non-compete agreements, they are enforceable, there's very specific language that is required in order for the courts to enforce them. So these kind of agreements, they need to be very narrow and very tailored in order to be enforced when it goes in front of a court. They must be reasonable as to time, geographical area, and the scope of the activity that is being restricted. So for example, time. Normally we see a non-compete, you know, that extends for a year. Sometimes you can get it up to 18 months, but normally the reasonable time for this to be enforced would be a year. The second one, geographical area. Something reasonable would be like within 5 miles of your business. Some people think that 20 or 25 miles is reasonable, but there's been cases where the courts have ruled that to be very unreasonable. And like I said, in Texas, they encourage competition, and they don't want you to be to have people who, you know, all of a sudden can't be working because there are these restrictions that extend beyond reasonable geographical areas. And the last one, the scope of the activity restricted, that one tends to be a little bit easier to determine. It basically means you can restrict them from doing an identical job that they were doing at your business. You restrict them from doing that identical job somewhere else. So for example, if there is, you know, a salesperson, well, whatever they were doing at your company, now you can restrict them in a non-compete agreement, with a non-compete agreement, from doing the same job somewhere else within 5 miles. And they know that with this agreement, they can't go out and, you know, find a job to do the same duties that they were doing with your business for approximately a year or so. And really, it's really important to keep in mind also that this only applies if it is the exact same product or the same competing market. So if you have, for example, a painting company, and you had this employee that worked at your painting company, and so you were focusing more on the residential properties part, and now this employee wants to go to another painting company, but they focus more on the commercial, you know, commercial properties. So that's not really the same market, and there's not really a need for a non-compete in that case. This is the example that we talked about. So in addition, an employer can also prohibit a worker from taking clients, customer, employees, and independent contractors from your business when you leave the company. This is the non-solicitation. So anytime that you are preventing someone from taking or going after your clients or your customers, that's when the non-solicitation agreements come into play. And they are subject to the exact same 3 requirements that we mentioned previously, meaning the time, geographical area, and the scope of the activity. So that's the difference between the non-compete and the non-solicitation. But just like I said, keep in mind that they both apply with the 3, you know, they're subject to the 3 requirements. And like I said, it has to be more like a mirror job that it comes into play. One of the problems that we have seen repeatedly is trying to figure out whether these agreements, you know, have restrictions that are deemed reasonable by the courts. So it's very, very rare to see that the courts and the business agree on what is reasonable. Like I said, maybe you would think that restricting them 20 miles from within your area is reasonable, but the courts have disagreed with that. And, you know, when they do, then that's just going to mean that you went through all this trouble to take disagreements in front of a court to have them enforce the agreement. Well, now the problem is the court disagrees. They say, no, it's not reasonable. You cannot be restricting this person to the extent that you want to restrict them from finding another job. And you went through all that trouble, you hired the attorney. Well, the court disagrees, and now you're left, you know, having to pay your attorney fees, and you don't receive any money in return, right? You're only going to have the court review the agreement, redline it, say, this is what's wrong with it. It's not reasonable. They're going to give it back to you, and that's it. There's just not going to be any compensation for you in return for all of that. So that is the danger of the non-compete and non-solicitation agreements. They are very, very costly, and they're, you know, they're very tricky because reasonable is a word that is very hard to define. And in front of the court, it's ultimately up to their discretion to decide. So like I said earlier, you know, the non-compete and the non-solicitation, they're good to have. However, they're not the most cost effective or the best economical decision for your business. So we can talk a little bit more about some other options that you may have when it comes to what are some better ways to, you know, protect yourself and protect your business. First of all, it's always very important to talk to an employment law attorney, get them to understand your business and how you operate. And that way they can effectively tell you, you know, this is the best way to go about a non-solicitation agreement. This is the best way to go about a non-compete. And there is never a guarantee that it will be taken in front of the court and, you know, be deemed reasonable. But attorneys that have experience doing this can help you get closer to being found reasonable in the courtroom. And if, you know, you go to an attorney first instead of kind of doing it on your own, this might save you time and money in the future in case you ever need to take this in front of the judge. One way to protect your business, apart from the non-compete, apart from the non-solicitation agreement, is the Texas Uniform Trade Secrets Act, or TUTSA for short. This law basically protects a worker from taking and using a trade secret when this worker leaves your company. So even if your employees do not sign a non-compete, even if they do not sign a non-solicitation, well, you still are protected in other ways because TUTSA now is going to protect you, even if this person doesn't have a physical list of your clients, right? If they somehow memorize a list of your clients and now they're taking that to another company, well, this person is now going to be liable under TUTSA. And if the company decides to use those same clients or customers or independent contractors, whatever it may be, well, now that company is also going to be liable because they have stolen and taken over trade secrets. So both are going to be liable. And like I said, it doesn't matter if it's just even through memorization, your trade secrets are protected under the TUTSA law. Another level of protection that's already built into the law, it's something that's called tortious interference with a business contract. So this basically means that you can sue someone for interfering with your contract, right? You already have all these standing contracts with other businesses, and all of a sudden, someone, like, they're not working with you, right? One of these businesses is not working with you anymore, and it happens to be that after one of your employees left, they took this business with them. Well, that employee is going to be liable for tortious interference with a business contract because you had a contract. They knew you had a contract with this other business, and they stole that from you. And like I said, you know, that's something that is already built into the law, and you're not required to sign anything for that. You're not required to have your employees sign anything. It's just kind of like this automatic protection that you already have. And so we can, talk a little bit about an example. Let me see if my example's here. No, okay. Well, one example could be, you have Joe, who is a salesperson. Joe has been with your company for a long time, and Joe knows that you have this long-standing contractual relationship with ABC Painting, right? So the ABC Painting supplies your paint. Joe knows about this. Now Joe decides he's going to leave your company and go work for a competitor. Next thing you know, ABC Painting stops purchasing paint from you, and has now moved on to do business with Joe and his new employer, who happens to be your competitor. Well, even if Joe never signed any agreements with you to prevent him from taking away any of your customers, you can still sue him under the tortious interference with business contract. Like I said, he knew of your long-standing relationship with ABC Painting. He interfered with that contract, and that has led to you no longer having that contractual relationship with ABC Painting. So both Joe and his new employer, the competition, both of them can be held liable. And now you can go and get money and damages for them violating the tortious interference with a business contract law. So that tends to be an easier way. Like I said, no agreements are necessary, and it's more of like a direct route to claiming those damages if this person violates it. Another level of protection for your company is to get your employees to sign a confidentiality agreement, and to get any independent contractors to sign independent contractor agreements. Confidentiality agreements, they tend to be something that's a little more friendly. Like, people would rather sign a confidentiality agreement over a non-compete or a non-solicitation agreement. It's something, a confidentiality agreement can be tailored to your company and each worker's job position. And it's just there, you have something in writing that kind of reminds your employees that all of this information needs to be kept confidential, right? So within that, you also have trade secrets that could be incorporated. And like I said, both independent contractors and employees can sign this. And it's just a good way for you to remind your employees, hey, all of this information needs to be kept confidential for up to a year after you leave my business. And it could include provisions preventing the solicitation of customers and employees. And it's, an easier way to enforce the restrictive covenants, essentially. Let's talk a little bit about the importance of documentation and timekeeping. It's very, very important that you keep proper documentation at all times, because it's going to prevent major issues in the future. I know it's a hassle. I know it's frustrating, or, just tedious work, but it's going to be worth it, because if at the end, they, whether it be the Department of Labor or whoever is trying to figure out, your documentations, it's going to be more of a problem later on. So it's better to just take care of everything from the start and make sure you're doing everything and keeping up with all the employment documentation that you need to have, and have that prepared and up to date, so you can make sure that your business is safe overall. So let's talk a little bit about what kind of employment documents you need, just so you can keep in mind. So here we have examples of some of the important employment documents. This is just a small list. It doesn't mean that it's everything in here. Make sure to maintain either an electronic or paper copy format So we're looking at things like employee handbooks, progressive discipline policy and forms, vacation, sick leave, PTO, confidentiality of trade secrets agreement, performance review forms, FMLA forms, benefits policies, expense report forms, all of that. Like I said, it's very important for you to keep track of everything, this list of documents. And this is something that our firm can help you with. If you need assistance with any of these documents, we can help you kind of draft one up and figure out, okay, what's going to work best for your business. Records and why you need them. A very common mistake that we see a lot is that we have some clients that come to us and they have not been keeping employment records, and we always advise them of the dangers of that. Spending a little bit of time making sure everything is in place, all your paperwork or your policies, all records of all employees. If everything is in order now, that will save you a lot of time and a lot of money in the future. These records, like I said, they're very essential. If any issues arise with any of your employees and you have kept record of everything, it's easier to now not only build your case, but also prove your case against them, right? If anything, they come at you with any kind of argument of discrimination, or whatever it may be, well, okay, I have all this proof to show you that, for example, you weren't fired because you were a woman, or because you're a male. You were fired because you were always late. Whatever it may be, your paperwork and all records, that's what's going to help you later on in the future if any issues arise. So we have, some forms. One of them is the performance reviews, also known as progressive discipline forms. And these allow you to measure employee progress or problems and create the necessary paperwork when it's, it comes for a termination, right? So in Texas, you can basically fire a person for any reason that's not discriminatory. But there's a lot of cases where wrongful termination, it's very easy for a plaintiff to prove and file and just create any issues for your company. So we're going to look a little bit more into some examples of how you can protect yourself in this case, and just more than protect yourself, also just prepare from the very beginning. Normally, when there is a wrongful termination case, there's like a series of steps, and it looks like a lot of back and forth arguing that goes on between the employee and the employer. But first we have the employee trying to prove that he or she was part of this protective class, and all of a sudden he or she was discriminated, and the burden of them proving that they were discriminated is very, very low, meaning they don't have to do much to prove discrimination, or to even argue it. So like I said, they're going to say, I was part of this protected class, I was qualified for the job, and I was, discriminated about against, and other people in similar situations, like they're fine. So after that, the employer is now going to have the opportunity to provide a legitimate, non-discriminatory reason for basically terminating the employee. And after that, the employee can basically show, well, no, the reason that the employer is giving is nothing but a lie, right? And the employee can continue to make up arguments and continue to raise up other issues, and then you're gonna go back and try to argue against that. And like I said, lots of back and forth, but this can all be avoided if you have the proper documentation, the proper paperwork that's gonna be the evidence that's gonna help you, build your own case and protect yourself from all this discriminatory arguments. So that's the importance of making sure everything, all your records and all your documents are up to date. Like I said, the paperwork is going to come in handy. This back and forth becomes very expensive very quickly, and it's most likely going to need to go in front of a jury, and the jury is going to be the one determining whether or not this person, was discriminated. And juries, they tend to just like a person for whatever reason. They will like you because your hair is pretty, or they will not like you because your clothes is wrinkled. Whatever it is, they're gonna find an excuse to, go, or not an excuse, but a reason to go one way or the other. And if you have that physical proof of all of your documentation, you're gonna have the attendance sheets, the time sheets, and you can go ahead and show the jury, well, look at my employee handbook, right? We had a rule about being on time. She signed it, she agreed to it, but look at her time sheets. She wasn't on time. She was always tardy. She was consistently late to work. So she didn't follow through with the employee handbook policies. And look at all of this other, for example, if the employee is a female and she's saying that you're discriminating because she's a female, well, all these other male employees, I keep them because they're always on time. Like all the other people are not getting treated differently than her, and therefore there's no discrimination. If you can prove all of that up with your proper documentation in front of a jury, well, the evidence is right there in front of them now. Right? It's not a lot of back and forth, he said, she said. It's hard, concrete, written evidence that they can now look through and analyze to make their determination at the end. And so this is the end of our, presentation. Like I said, make sure you're always keeping track of everything and all your timekeeping records. Make sure they are, everything is up to date. And that way you can, like I said, in case any issues arise in the future, you can better prepare for everything. Make sure that you understand and go over the 5 factors that we looked at earlier. When it comes to classifying your worker as an employee or an independent contractor, and that will help you determine ultimately how you need to pay them. The last thing you want to do is run into a messy situation with the Department of Labor or the IRS, excuse me, and it's best to just protect yourself from the start and avoid a hassle in the future. Another thing I wanted to tell you guys is we ran out of time, I think, for questions, but you can always contact our office. I don't know if we have our information here, but you can always contact our office. We have 30-minute free consultations for everybody. Talk to an attorney about your case. Let them know, hey, this is my business. This is what we do. Am I paying this person correctly? Whatever it is, we can talk you through that and kind of figure out what are the best steps that you need to take to make sure you're protecting yourself. Thank you guys so much for your time, and thank you for joining us.
Thanks, Myra. As Myra said, we will be sending, I will be sending a follow-up email. We'll have the YouTube link. This was recorded session, so it'll be up on our YouTube here in the next day or so. So I will be sending an email with that, the full presentation, Myra's contact information. If you have any questions at all, like she said, we do have those free 30-minute consultations. And we hope you join us for our next webinar next month. I will be sending all the details and the RSVP link in that email here in the next day or so. And again, we appreciate your time and hope you can join us for the next session. Hope you all have a great day.